microphone, please.
Thanks very much, Joe. Good morning to the panel, and thank you for joining us this morning. And thank you, too, for your opening statements and the evidence that you've submitted in advance, too. I'm interested in exploring a couple of different areas, but the first one I want to pick up on is that of gender dysphoria and the removal that this bill suggests, the removal of a requirement for the diagnosis of gender dysphoria. There's this discussion around the distinction between whether gender dysphoria is a mental illness or not. The WHO and the UN are quite clear that it is not a mental illness. And I was just wondering if you could speak a little bit about what your views are around the evidence required, or the lack of evidence, in your view, required around gender dysphoria. And I'll start with Lucy, if I may.
Thank you. So one of the things, if I take a step back, that we asked civil servants when we met them was what kind of option analysis there'd been of alternatives to taking out the diagnosis of gender dysphoria when they were looking at the bill. And one of the things we were surprised to learn was that they hadn't looked at any other alternatives that retained any form of medical gatekeeping. They had gone straight to just the self-ID model. And that bothered me as a former civil servant, that there'd been, over all this period, no kind of option appraisal of different ways. And medical gatekeeping here, I think, is something which has various things. But one of the things to talk about is the relationship between the two tracks. And Malcolm made the point between the medical world and the legal world, and the idea that these are two quite separate things. So when you go back to the original Gender Recognition Act, Justice Schofield said, the requirement for a diagnosis, and more especially the requirement for a medical member of the panel, demonstrates that Parliament in 2004 considered it proper to have some read across between the two processes in the way of professional clinical involvement in each. And I was looking at, there's interesting stuff we can send the committee from Denmark, and again, to pick up on Malcolm's point about what happens when you start to decouple these two things. So Dietz, in 2018, writing very much from a perspective of someone who supports self-declaration, I should say, argues that in Denmark there has been a problem, that they feel that it hasn't worked well because of the decoupling. And in fact, what's happening is you're seeing in Denmark now a desire to make access to the medical treatment pathways self-declared too. Now, obviously, as you'll know, at the moment, the access to the NHS depends on a diagnosis. So this decoupling of law and diagnosis, I think Malcolm's exactly right. The committee needs to watch the idea that you can do one. You have two parallel systems that work together, and Denmark is really interesting. We'll send you the material. So for our point of view, the medical gatekeeping it connects in there, it avoids this dislocation, and it creates an oversight. And a lot of the problems that people are raising with self-declaration are, if you have some medical oversight, as you still have for passports, of course, then you have an external third party. And that brings in something which actually deals with an awful lot of the concerns that people have about self-declaration. I'll pass to others. Yes.
Before I bring you in, Susan, you spoke in your opening remarks around the eligibility criteria more broadly, not only just associated with gender dysphoria. I wonder if you could say a little bit more about what you consider to be legitimate criteria and not, and why.
But I think to an extent that's not really for us to say. I think there needs to be, we're not here to determine what the eligibility criteria should be. We're just here to say that you shouldn't remove it in its entirety, which is what this bill effectively does. I would go back to this idea that, I know you picked up on the WHO. It's interesting that has slightly decoupled the WHO has slightly decoupled from the American Diagnostic Statistical Manual of Mental Disorders, who do still link gender dysphoria as a mental health condition, and usually those two groups work together. So there has been there is a tension within that. But going back to the WHO, ICD-11 moved the gender incongruence from the heading mental behavioural disorders, but they do keep it as a condition, in this case a condition related to sexual health. And one thing that the authors of a paper who sat on the working group have stressed is that a diagnosis of gender incongruence must be retained to preserve access to health services for those who need them. So that, going back to this idea of this potential decoupling of medical services. It's very important that even the people who are taking it out on the WHO really think that those diagnoses are important. This was also borne out in a case heard in the European Court of Human Rights recently, which decided a requirement for a diagnosis was aimed at safeguarding the interests of the person applying a gender change to ensure they do not embark unadvisedly on the process of legally changing their identity, and applied the proportionality test to ensure that rights granted to a particular group do not interfere with the rights of wider society.
I'm interested. You talk about that shift from mental disorder to sexual health condition. I think is the language DSM use. Why then would we have a psychiatric assessment? Why would it be problematic? Susan, I'm asking you to answer this. Why then would it be problematic to remove the psychiatric assessment element?
I think because they are saying that you need to maintain that diagnosis. I mean, even the people who've moved it have said you needed to maintain a diagnosis.
Sexual health is different to mental disorder.
Yes, of course.
It's important.
Sorry, I'd like Susan to answer this, please, given she raised it in her evidence.
My letter to the committee just points out that the Act doesn't describe gender dysphoria as a psychiatric diagnosis. That's all the point I wanted to make. So nothing in the GRA ties it as drafted to being a psychiatric. There is an issue about a definition in Section 25 of disorder, which Justice Schofield criticised. But I want to make that point because there isn't anything in the face, and we're here to talk about the Act, obviously. There's nothing on the face of the Act that requires it to be regarded or conceptualised as a psychiatric diagnosis. That's the only reason I wanted to intervene.
Yes,
Okay.
I think that's the crucial point, that the diagnosis, it doesn't matter what heading you put the diagnosis under, the diagnosis has to remain.
Kate, if I can come to you, you mentioned in your opening statements the requirement of gender dysphoria to remain. Can you just say, is your view aligned with what Lucy and Susan have just said?
I'm going to defer to Lucy and to Susan on their knowledge of how things currently operate. What I would say is that the policy question of the appropriate management of cohorts of prisoners who have a diagnosis of gender dysphoria or who have gender dysphoria but who have not obtained a formal diagnosis, and the particular vulnerabilities that they may be experiencing in the prison estate. That is an urgent question, but it's an entirely separate policy question as to which cohorts of prisoners have a legitimate entitlement to be housed in the female prison estate and to be managed in accordance with the risk assessment processes, searching protocols, etc., that are in place for female prisoners. I agree that there is an urgent issue regarding the vulnerability of prisoners, which, as we know, unfortunately extends beyond these cohorts. But I'm focusing on the legitimate entitlement and the impact on the female prison estate. I could give just one example. I mean, there was a prisoner, someone who's now a prisoner in Ireland, who was refused a diagnosis of gender dysphoria at a clinic in England, and so was unable to pursue a GRC through that route, but who then, on the basis of self-ID, was able to obtain a GRC in Ireland. And the impact of the management of that prisoner within the female estate has been catastrophic for women in prison.
Okay, thanks, Kate. Malcolm,
Thanks,
if I can come to you, you also mentioned gender dysphoria and the need to retain that in your opening remarks.
Yes, as I understand it, the 2004 Act had the gender dysphoria diagnosis and various barriers to giving a GRC. In order to protect the public, it was an assurance. It was sold to the public then as an assurance that not just anybody could get a GRC. Now, I agree with my colleagues here, but I would also say to a parliament that's considering giving GRCs to 16 to 18-year-olds, I would have thought that some sort of medical, psychological barrier would be helpful to a 16-year-old. If nothing else, I mean, nobody I've ever heard has said that the the medical diagnoses that were provided up to now in the GRC were really traumatic and dreadful and intrusive. As far as I can understand, they asked simple questions. And I would have thought at the very least something has to be retained for 16 to 18-year-olds, if nothing else, that asks them, are they sure, and explores why they feel the way they do. And that if gender dysphoria is an issue, it should be explored in a therapeutic and caring way.
Can I just clarify, you saying that you don't, in your view, you don't consider that the process as it currently stands is demeaning and intrusive?
From the people I've spoken to, and I know many trans supporters of LGBT Alliance, both transsexuals and transgender, they frankly guffaw at the nonsense that is being described as demeaning. I mean, nobody ever puts any flesh on this term demeaning. I mean, what is it, a couple of questions? You're about to change one of the most fundamental legal definitions of an individual in society, and we're not allowed to ask a couple of questions?
Okay. Final point, if I may, Joe. It's actually linking something you've just said, Malcolm, to Lucy, something you said in your opening statement. Malcolm, you said the proposals under the Gender Recognition Reform Scotland Bill would mean that anybody could get a GRC. That's what you've just said. Lucy, in your opening remarks, you talked about opening this up to a more diverse group, a wider group. What do you mean by wider group?
Thank you. That's a very important question. And one of the issues here to us is very much the larger, more diverse groups. At the moment, the threshold for getting a GRC, so it's presented very much as we're just changing the admin for a set group. But when you look back at 2004, the group that's legislated for was deliberately, they expected it to be the 5,000 or so people that it is. And it was very deliberately pegged around people. Justice Schofield, as I said, went through, it's very interesting judgment, went through the background of the 2004 Act and how it was very much intended for this very tightly defined group, and EHRC's made the same point. Once you drop the threshold, one of the problems about removing any kind of medical oversight, however you construct it, is that you open up to anyone who is willing to make the declaration. And this is a problem, that your threshold, your safety threshold there, not your safety threshold actually, but because some people may be entirely genuine, so it's not just about saying it's abusive. Literally, you're writing a piece of law, because the law is what's on the page, it's not what's in anyone's head at the time. All that's required. Yes.
Can I just say, so what is it that you mean when you talk about the wider group?
The wider group is the wider group of people who are not dysphoric, who would at the moment not be able to acquire a GRC because they would not be able to get a diagnosis. So that and this is this is a serious decision for you as a committee, is what is this act for? I think it's a very helpful question to have at this point, because the 2004 Act is being really repurposed here to do a different job. It's originally designed very clearly, when you read the Hansards, it's very, very clearly designed for this very small targeted group of people who are envisaged as being long-time transitions, having made quite major changes, needing extremely acute privacy protections. But what you're hearing, and I've read the evidence to the committee and listened with great interest, and what you see being laid out in front of you is a really different conceptualisation of the population of interest to politicians here, as a much broader group of people. In some of you've got written evidence, people saying that they don't think you should have the acquired gender period because you might not be able to live in your acquired gender. People wanted to say that they should be able to apply for a GRC regardless of whether they've made changes. You have, and that was actually answered in the Spice briefing, but some of your written evidence, people make the same points. I think Ellie made some of the same points too. That the population that's talked about, the umbrella, the trans umbrella now, is radically different in its composition. It's bigger, it's more diverse. And that's, that's where we are.
Maggie, one of the problems that I've always found when debating this in Scotland is that there is a giant loophole created by the law. I call it, if you like, the Alex Drummond problem. I mean, you may know that Alex Drummond is a 6'2" Welsh lesbian with a beard, looks like a man, but his approach, he says, is he's queering the idea of gender by the fact that he knows he looks like a guy and he's got a big beard. And I always say, well, once you have opened to a wider population and the public know that you've opened the GRC to a wider population that may include 6'2" blokes, people who look like blokes with a big beard, then how is the public supposed to know when a 6'2" person with a beard who looks like a guy walks into a girl's changing room? How are they supposed to know whether this person has a GRC, is trans-identified or not? And there's a huge loophole here that it would be great if finally, after the 4 years of this bill being talked about, that politicians would finally consider how they could close that loophole.